Hello friends, today I am going to give you a basic overview of data protection laws used in the EU at the moment and briefly mention the proposed draft data protection regulation which is currently in consultation mode. So what is data protection? Data protection laws serves to control the collection, dissemination and use of personal data. European data protection law hinges on the protection of personal data related to a living human being. The EU's personal data definition is much wider than the US's narrowly defined personally identifiable information. The two should not be confused. The EU's data protection legislation gives rights to those living individuals in the EU. Some member states do give some rights to dead individuals, but those will not be addressed in this video. The main data protection legislation used today is Directive 95/46. We have a proposed draft new regulation. The differences between a directive and a regulation is a directive is an instruction to member states to impose legislation which fits the purpose of the directive. In the UK, we have this in the Data Protection Act 1998. Regulation in itself is a positive act which is immediately legal to all member states. When the proposed draft EU regulation comes into play, there will be no more individual member states' legislation to do with data protection. They will all abide by one regulation on data protection. Why is this important? Well, currently the directive gives individual member states and their respective information commissioners room for manoeuvre when it comes to interpreting the law and taking action against those who are misusing or mishandling personal data. There is inconsistency amongst member states. The EU is about creating a single market, and there has been much criticism that the Data Protection Act has not created harmony and consistency within the EU. Individual states have their own interpretation of the legislation. This has not made it a level playing field for handling personal data of EU citizens. Major organisations currently trying to handle personal data across jurisdictions are finding the bespoke interpretation of the legislation by member states a major headache. With the new regulation, it is hoped that it will do away with some of the issues that major companies are finding themselves in. The consistency of the law across the EU member states is a very good thing for organisations. Also, the proposed draft regulation aims to increase penalties for misuse, mishandling of personal data. And of all the things the new regulation aims to introduce, the penalty regime is the one that organisations are watching very closely. Currently within the EU, major organisations have made the business decision not to adhere to the data protection legislation because there are hundreds of millions of euros to be made by breaching the data protection legislation, because by the time the authorities, the commissioner, have caught up with them, they would have made their money. And the fines currently imposed are minuscule in comparison with the profits they have made by breaching the data protection legislation. Currently, the proposed draft regulation is going to fine organisations for a breach of personal data an X percentage of their profits rather than a ceiling cap of a six-figure sum, which for some organisations is loose change. There are three main characters in the data protection legislation: the data subject, the data controller, and the data processor. The data subject is the living person to whom personal data relates to, the person whose rights we are trying to protect. The data controller is the person who controls the dissemination of personal data, the person who is making the business decision about how the personal data will be used. The data processor is the person who is following orders of the data controller. The data processor does not make decisions on how data is collected, used or disposed of. The main regulatory duty of the data processor is to do what the data controller says. The best way for the data processor to get into trouble is not to do what the data processor says. So what does it mean to process personal data? This is the definition. This covers positives and negatives, like when deciding to use or not to use personal data, when or when not to dispose of personal data. This covers a lot of areas. If you look at or even think about personal data, you are processing it. Why am I highlighting this? Because once in a while, someone within an organisation will say, my compliance strategy is I do not process personal data. My answer to that is, if you have personal data anywhere in your system, you are almost processing it. Let's now think about anonymising and de-anonymising personal data, and let's look at the definition again. Personal data is data that relates back to a living individual, whether or not you handling that information can make that correlation or not. If someone else in the world can correlate the information that you have to a living individual, you are handling personal data. Now let's think about de-anonymising data. If I give you the first part of my postcode, tell you I'm a British Asian male who drives a Jaguar, this constitutes personal data. There is only one living human being who matches those characteristics, and that is enough to lead you to me. It is shocking how much little data you need to reverse engineer and find a living human being. A lot of this has come from mapping activity, which is picked up from apps and social media. There was a study recently that showed if you give someone the start address of their journey to work and their work address, 8 out of 10 will identify the person who made that trip. De-anonymising personal data is an exciting new research area. Data subject rights. Data subjects have rights to ask the data controller, show me what you know about me. Data subjects can bring lawsuits for violations of their personal data by the data controller. So when is data processing allowed? In theory, processing personal data is allowed if you have the data subject's consent. Lots of compliance officers say getting data subject's consent is easy. I would say in response, if you are relying on consent, you are doing something wrong. Why? Because getting consent is expensive. It involves you having communication with the data subject. You have to send letters to the data subject, throw pop-up windows when they click on something. You even have to explain things in detail to them. And at the end of the day, the data subject can revoke their consent. For example, if a data subject from London travels to Berlin and is involved in an accident and is in hospital, the GP in Berlin does not need to get the data subject's consent to access their medical records in London, because they need those records as a matter of life or death. It is in the vital interest of the data subject. So the Berlin hospital can obtain those records from the London hospital to heal data subjects. The final point is where most data controllers live and occupy, rather than consent. Obtaining consent is easier if the data subject is your customer. This is the reason why banks routinely send paperwork about new policy, because they know where you are to send details of updates. Getting consent is one thing, but if you as an individual or organisation handle special personal data about the data subject, your legal responsibility is elevated. If you handle any of these, your compliance strategy becomes more expensive and more time consuming. There is a simple yet tragic way of remembering these categories. All you have to remember are what are the categories of personal data that would have sent you to a death camp in the Nazi regime or persecuted by the Indian government in the 1980s. It's a tragic truth that these categories exist, and a political truth that European countries are sensitive to processing these special data because we have living memory of what modern states can do with access to bulk data. If you are an organisation or an individual that handles special data, you better have staff that are trained and know how to handle and comply with the information, and the budget from the board to introduce technical and procedural controls. If you are a hospital, you will have this data and have to manage it sensitively, unlike an electricity company that may have names, addresses and how much electricity the data subject uses, but may not have the same headaches as a hospital, as the electricity company does not have special data. There are 8 big data protection principles. The first one may appear easy, but often many get wrong. The best way to answer this is this the type of thing that the data subject would expect me to do with this data? In the 1980s, before British Gas was privatised, they realised their biggest asset was customer details. They sold this data to an insurance company, and the court held this is not the kind of activity customers expect when they sign up to a gas company. They do not expect their data to be sold, nor do they expect cold calls from a third party. It was held this was not fair processing. If you educate your customer, there may be circumstances where data can be shared to a third party. This is one of the reasons why banks send us letters saying our information is held securely and privately by a trusted third party, and different departments within the organisation to prevent fraud, for example. If someone then complains in 24 months' time, the bank will then say, whoa, you didn't say anything when we messaged you 12 months ago. This is how you fashion a compliance strategy. You don't ask your customer to tick a box to agree to what you're going to do next, as this is expensive, as you need to keep consent records. Instead, you have to keep records of communication you have made between parties and customers. The next point on retention is also tricky. No organisation wants to delete customer records. The only organisation I have come across that strictly adheres to retaining data longer than necessary are government departments. The next point is security. What do we mean by security? Directive Article 17 discusses what is meant by security. What this is saying is at policy level, data controllers owe a duty of care to data subjects. Data controllers must take reasonable steps. This point emphasises that information security is not just about the technology like cryptography, but is about ensuring processors know their responsibilities and have adequate training. This makes it suitable for different sized organisations. Now we are going to look at a data protection case study, more specifically the HMRC data breach. The National Audit Office requested 10,000 records from HMRC of child benefit records. HMRC, however, decided to go one step further and send the Audit Office their entire database of 25 million records. The National Audit Office did not request the full 25 million records, they only requested a snippet. Also, the HMRC sent all details regarding child's names, addresses and how much they were claiming. The National Audit Office requested a snippet of the columns. Unfortunately for HMRC, the CDs that contain those 25 million records went missing. What were the data violations here? Let's have a look. What data protection violations can you spot? over 90% of media reports focused on the security lapse. But what people should have been focusing on was why did HMRC send their entire database rather than what was requested by the Audit Office with reduced fields. In fact, is it not fortunate that this data was not disclosed, because disclosing the data would have been more damaging than the security lapse. Why did HMRC send 25 million records rather than the reduced levels that was requested? To save money. HMRC had outsourced database management to a third party, and they had asked them how much it would cost to extract a specific amount of records. The managed third party said because it was not within their regular contract, they would have to write code and have project meetings, which would have cost HMRC X amount of money. So HMRC responded, sod this, we'll get it for free by copying and pasting the database within a few seconds. It's this reality of cost modelling and data handling which causes data breaches. It is far less expensive doing the wrong thing than doing the right thing. Directive 95/46 applies to persons who have an establishment in the EU or those who make use of equipment in the EU. So this is a summary of the current law and its application. And this is the proposed regulation. As you can see, using equipment in the EU is not the ultimate trigger. Rather, are you offering goods or services to or monitoring persons who are resident within the EU? To the EU citizen, this makes much more sense. The bottom line for organisations is if living humans in the EU are your customers, clients, staff, marketing targets, etc., then data protection laws within the EU probably apply to your activity. The EU is not hating on the cloud, it likes the cloud, so long as it is regulated, which unfortunately in some international jurisdictions it is not. Therefore, if you are a US company, for example, and you have one customer in the EU, you have to comply with the regulation. But how much do you invest? This comes down to legal risk management. How much money are you making from that 1 or 100 customers in the EU? When you start making a lot of money from the EU, you better start protecting yourself. If you have zero assets in Europe, you're making zero money from Europe, then you won't invest in security for it. I hope you found this brief overview of data protection legislation and the proposed draft regulation within the EU useful. If you have any questions or comments about data protection legislation, please drop us some comments below. Thank you for watching.